Hey everyone, welcome back to Civil Score. So happy to have you here today. Now, if you are preparing for UPSC Prelims 2026, you are in exactly the right place. Today, we are starting with one of the most tested portions in Prelims, fundamental rights, specifically the right to freedom, covering Articles 19 to 22. So grab your notes and let us get into it. Alright, before we go into the details, let us understand the big picture. The right to freedom is not just one article. It is actually a cluster of 4 articles working together. Think of them as 4 pillars holding up your freedom as an individual. Article 19 gives you the 6 core freedoms. Article 20 protects you if you are accused of a crime. Articles 21 and 21A deal with your right to life, personal liberty, and education. And Article 22 protects you against arbitrary detention. Each one has its own scope and its own exam importance. Now, one very important thing before we go further. When we say the state in this context, remember what Article 12 tells us. The state is not just the central government. It includes parliament, state governments, state legislatures, and all local or other authorities within India or under the control of the Government of India. That definition matters a lot when we talk about restrictions on your freedoms. Now let us talk about Article 19. Under Article 19(1), every citizen of India is guaranteed 6 fundamental freedoms. First is freedom of speech and expression under 19(1)(a). Second is the right to assemble peacefully and without arms under 19(1)(b). Third is the right to form associations, unions, or cooperative societies under 19(1)(c). Fourth is the right to move freely throughout India under 19(1)(d). Fifth is the right to reside and settle anywhere in India under 19(1)(e). And sixth is the right to practice any profession or carry on any occupation, trade, or business under 19(1)(g). Now here is a very important note for prelims. There used to be a 19(1)(f), which was the right to property. That has been repealed by the 44th Constitutional Amendment in 1978. So currently, there are only 6 freedoms under Article 19, not 7. And one more thing. These freedoms are available only to citizens, not to foreigners or non-citizens. Now here is where Article 19 gets a little more layered, and this is very frequently asked in prelims. The state can impose reasonable restrictions on these freedoms, but those restrictions must fall within the grounds specifically mentioned in the Constitution. For freedom of speech under 19(a), the state can restrict it on 8 grounds: sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. That is the longest list. For assembly under 19(b), restrictions can be imposed only on grounds of sovereignty and integrity and public order. For forming associations under 19(c), the grounds are sovereignty and integrity, public order, and morality. For movement and residence under 19(d) and 19(e), restrictions can be placed in the interest of the general public or for the protection of scheduled tribes. And for profession under 19(g), the state can restrict on grounds of general public interest, professional or technical qualifications, and state monopolies. Remember, no 2 freedoms have the same list of restrictions, and that is exactly what UPSC loves to test. Article 20 protects a person who is accused of an offense. And what is important here is that Article 20 cannot be suspended even during a national emergency. That makes it a very special article. It has 3 protections. The first is under Article 21, which says, no person can be convicted for an act that was not an offense at the time it was committed. This is the prohibition of ex post facto laws. Also, the penalty cannot be more than what was in force when the offense was committed. The second is under Article 22, which is double jeopardy. No person shall be prosecuted and punished for the same offense more than once. The third is under Article 23, which says, no person accused of an offense can be compelled to be a witness against himself. This is the right against self-incrimination. All three of these are very clean, very exam-ready points. Article 21 is arguably the most powerful and most litigated article in the entire Constitution. It says, and I want you to remember this word for word, no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, there are two things to note here. First, it says no person, not no citizen. So this protection applies to every human being on Indian soil, citizen or non-citizen alike. Second, the phrase procedure established by law has been interpreted very expansively by the Supreme Court over the decades. In the landmark Maneka Gandhi case of 1978, the court held that this procedure must be fair, just, and reasonable. It cannot be arbitrary. Over time, Article 21 has been read to include rights like the right to privacy, right to a dignified life, right to livelihood, right to health, and much more. For prelims, just keep in mind, Article 21 applies to all persons, and it is the most expansively interpreted fundamental right. Article 21A was inserted by the 86th Constitutional Amendment in 2002, and it gives constitutional status to the right to education. It says, the state shall provide free and compulsory education to all children between the ages of 6 and 14 years. The manner in which this is implemented is determined by state law. The practical legislation giving effect to this is the Right of Children to Free and Compulsory Education Act 2009, which you may know as the RTE Act. For prelims, remember, Article 21A covers children aged 6 to 14. It is a right available to all children regardless of their background, and the implementation is handled through state-specific law. Article 22 deals with protection against arrest and detention. The first part of Article 22 covers what we call punitive detention, which is arrest after a crime has been committed. When a person is arrested, they have 4 guaranteed rights. First, they must be informed of the grounds of their arrest as soon as possible. Second, they have the right to consult and be defended by a legal practitioner of their choice. Third, they must be produced before the nearest magistrate within 24 hours of arrest, excluding the time needed for travel. And fourth, they cannot be detained beyond that 24-hour period without the direct authority of the magistrate. These 4 protections together form the backbone of an arrested person's rights in ordinary criminal law. Now here is a very critical and frequently tested point. These protections under Article 22, the 24-hour rule and the right to a lawyer, explicitly do not apply to 2 categories of people. First, enemy aliens. Second, persons detained under preventive detention laws. This distinction is very important. When someone is arrested for a crime already committed, they get the full set of protections. But when someone is detained to prevent them from committing a future act considered harmful to state security or public order, different rules apply. That is what we call preventive detention. and Article 22 itself lays out how that works. Under the preventive detention provisions of Article 22, Parliament has supreme power to make laws on this subject. The base rule is that a person can be detained without review for a maximum of 3 months. If the detention is to continue beyond 3 months, it requires a report from an advisory board that confirms there is sufficient cause for continued detention. This advisory board must consist of sitting, former, or persons qualified to be appointed as High Court judges. Even a person held under preventive detention has 2 minimum rights. They must be informed of the grounds of their detention, unless disclosure would be against public interest. And they must be given the earliest opportunity to make a representation against the detention order. Parliament can by law prescribe longer maximum periods of detention and lay down the procedure for the advisory board. This slide is gold for prelims, so pay close attention. Punitive detention happens after a crime is committed. Its purpose is to punish. Preventive detention happens before any crime, to prevent a future threat. In punitive detention, review happens before the nearest magistrate within 24 hours. In preventive detention, review happens before an advisory board, but only after 3 months. In punitive detention, the right to a lawyer of your own choice is fully guaranteed. In preventive detention, there is no such right, only the right to make a representation. For grounds, in punitive detention, the person must be informed immediately. In preventive detention, the grounds can actually be withheld if disclosure is against public interest. This comparison table is something you should be able to reproduce from memory. And that brings us to the big picture that ties everything together. The Indian Constitution is a very careful balance. On one side, it guarantees individual liberty, your freedom of speech and movement under Article 19, your fair trial protections under Article 20, your right to life and education under Articles 21 and 21A, and your legal protection upon arrest under Article 22. On the other side, the Constitution explicitly empowers the state to protect society, public order, sovereignty, and national integrity. Through reasonable restrictions under Article 19, the procedure established by law under Article 21, and preventive detention under Article 22. Neither the individual nor the state gets absolute power. That is the essence of a constitutional democracy. And that is what makes these articles so central, not just to UPSC, but to how we live as free people. I hope this was clear and useful. As always, revise your notes, keep the comparisons handy, and keep going. You are building something great, one topic at a time. See you in the next class. Take care and all the best.